rate, so I just want to go over, each of you will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes if you so choose. You just have to let me know because I'm trying to keep time for you. And then also I want to make sure that the rules are when we're doing public and video oral arguments that we don't use the names of any victims. We don't use the names of any children. I don't think this is applicable here, but at the same rate, I just like to make sure I always say it so there's no misunderstanding, as well as I don't forget when the case is necessary to caution the attorneys on. All right, so we are ready to proceed then.
Thank you, Your Honor. I would like to reserve 5 minutes for rebuttal, just in case. I don't know if I'll use a complete 10 minutes for my case in chief, since most of what I've written in the brief is what I figure is controlling in this matter.
And just for purposes of the record too, we had so many problems with the technology, I forgot to even call the case. It's Steffen versus Steffen. All right, you may proceed.
Thank you. May it please the court, Your Honor. My name is Christopher Fortunato. I represent the appellant in this matter, Wallace Steffen. This is an appeal from the Probate Division of Lorain County Court of Common Pleas. In this matter, we have set forth 4 appellate arguments or assignments of error in this matter. And the one that is crucial here, being the first one, was what we believe is an error or perhaps an abuse of discretion on the part of the trial court in disallowing various credits, such as deductions for trustee fees, travel costs, professional fees of that nature, because we believe that not only in disallowing that, we have an unfair picture in terms of what should have essentially been an accounting to see how much money was actually owed by the appellant to the appellee after the trust was concluded when their father had passed away. Essentially, this is a case for a trust accounting in determining what type of advances the appellant took for himself in this matter, of which the appellee knew of and testified knowing, because she understood some of the problems that he had in his personal life and required some additional monies from the trust in terms of being able to fund divorce litigation in California. This was not the first loan that the appellant had taken while his father was alive and before his father was ill. The testator, the settlor of the trust, had loaned the appellant some money, and there was also testimony that the appellee had also been loaned some money, although I believe not as much as the appellant. And in this matter, the deductions which the trial court took or levied against the appellee were more, I believe, an abuse of discretion and in some ways a punishing of the appellant, as opposed to getting at an end in this matter that essentially was how much money did the testator have and how much money should have been divided up had there been absolutely no issues or problems of this nature at the conclusion of the trust. Because once the settlor had died, then the appellee and the appellant were supposed to split the assets of the trust. And it is the appellant's argument that the damages in this way, disallowance of certain deductions that were taken, were in many ways an abuse in terms of or a punishment rather than getting at a just result in this matter of who is actually owed what. And Therefore, we believe that this matter should be remanded back to the trial court for a hearing on damages alone in this matter to arrive at a better result of who was owed what in this in the winding up of the Steffen Trust. In addition, we believe that the trial court had erred in allowing Exhibit 15 to be entered into evidence because it was more a summary of damages as opposed to evidence of the damages itself. And we believe that under the one evidence rule that was cited in this matter based on the notes, the staff notes of that evidence rule, that something of this nature was in error. And therefore, if those things were entered into, we have sort of faulty evidence that is starting the damages analysis here. And we believe that that has to go back as well to the trial court so that we can take that out and put in the best evidence in this matter.
Counsel, I have a couple questions. Backing up a little bit on your first assignment of error, you're talking about the type of items that the trial court disallowed, like for instance, commuting expenses when the trial court said he was living in Ohio and he claimed he was living in California.
Well, I believe there was more than just that, but yes,
Those type of items, right?
Yes, those items. Of course, if there was actual proof there of living in Ohio and not California at that time, there was a portion of time where the appellant was doing that probably would not be admissible, although he did have to travel to California for his work where he was an airline pilot. So there was movement around. I mean, neither of these parties are local people of the 9th District. They grew up here, but their professions took them to the West Coast of the country. So there may be some need for that, but I would have to agree with the court that if one was living here, then that ability is not as strong as commuting back here to see a parent or to take care of the parent, except for the fact that he did have to go to the West Coast for his work.
Okay, what about the ones where if he's living here and he's claiming expenses for the house that he's living in? How is that an allowable expense?
You mean the house here in Ohio as
Right.
a house? Okay, that if he was maintaining a residence in California as a result. Well, aside from the fact that he would have to be paying rent or some other type of expenses to the trust for that matter. I've had that problem before, and sometimes people don't understand that. That most likely would not be as strong an issue for the appellant in this matter.
Now with Exhibit 15, one of the points that appellee makes is that even if it was wrongfully admitted, it wasn't prejudicial. So how were you prejudiced by that?
Well, I think it's prejudicial if the court used it at all to the court, is still in the record of the court and could possibly be used by the court in terms of computation of damages. I have the record right before me, but I don't know if the court had necessarily used the exhibit as much if he did not rely on it, and I don't, let's say that I don't think he really did in that case, although some of the damages and things that he referred would have been in that exhibit, although he did not necessarily cite to it. I still think there may have been some prejudice to the court or to the appellant in using it. But I would agree with your question that the trial court did not rely on that exhibit solely.
Counsel, you are now at 5 minutes remaining. If you'd like to save that for rebuttal or you'd like to continue.
I'd like to save for rebuttal. Thank you.
Thank you. Thank you. Ms. Steffen, for the appellee, or you are the appellee, I should say. You have 15 minutes.
All right. I'm Linda Steffen. I'm the appellee. I think at least the first two items that were covered, I think between the actual judgment and my response in the brief to the appeal, and even the questions that you just raised are pretty clear on the first item, that those costs were accurately computed, and that the reasons behind those were judgments, and the judgments were well supported in the original judgment. And I think the residency is an important issue, in that it's clear that he was a resident during that time and should be paying rent and shouldn't be paying travel cost, expense for travel costs. And these were costs to the estate, and the credits are fair and everything else, at least in my opinion, and hopefully the judgment also shows that. And the second one on Exhibit 15. Exhibit 15 I put that together in lieu of not having any of the accounting that was provided prior to the trial. So that exhibit was using the data that through subpoenas and everything else that I could use outside of what my brother was willing to provide in terms of the accounting. So that was walking in cold without the data. And it was used to question my brother during the trial, so that we could understand where there might be some missing items. And we discovered that there were missing items, and that was used just as a tool to that. The actual judgment was, and the calculation of the judgment were based solely on brothers Wallace, Steffen's his summary of the loans, and then items were removed or added to his based on what we learned during the trial, and that was the exhibit that was provided in the closing arguments. So I don't think Exhibit 15 was used at all in the actual judgment. The other two, in terms of the other items, was in terms of the time frame. Just to note that I spent $10,000, and this is all in my write-up also, spent $10,000 between 2013 and when that was filed. And before that, I was trying on my own to resolve with my brother the fact that the money was being taken and it was running out. And the delays, and most importantly, is that the issue around the costs. I certainly didn't want to spend my family's money of over $200,000 to resolve this issue. But each step where we tried to resolve and tried to get the accounting, there was some sort of delay, some sort of cat and mouse game that cost me significant money each step of the way. And I think that was my brother's strategy, was to bury me and my family with costs so that I would walk away from this. And so the result of having huge costs is part of his strategy, and therefore, I hopefully my family can recover at least part of that. And the recovery will be close to, and any sort of full recovery will be close to impossible because of the delays and the ability that my brother will retire. And that's why these delays are occurring. And this is why I believe this appeal is here solely in order to run the clock out on his ability to pay, and run up costs, and hopefully that I just walk away from this. So I think this was the strategy, and number 4 was accurately, and now it's my time, and I also have to deal with a bankruptcy that he has used to cause further delays.
Thank you.
You're welcome.
All right, seeing no questions, or hearing no questions, I should say, then we'll go ahead and go back to the appellant, and you do have 5 minutes remaining.
Thank you, Your Honor. In this, I don't think that the appellee at this time can make inferences or references to the appellant's state of mind in determining how what his reasoning is behind taking an appeal. He certainly has a constitutional right to an appeal, although certainly not in the way of a criminal defendant. This action was also initiated by the appellee, and she has all the burden of proof in this matter compared to the appellee, although the appellee certainly would want, or the appellant rather, certainly the appellant would want to bring forth his own response in such litigation, but it's the appellee's case. It's not the appellant's. He doesn't have necessarily a duty in that regard compared to the appellant's duty or burden of proof in proving this matter. And what I stated in my reply brief, of course, I think I would also restate here, in that things necessarily outside of the record of that sort, whether it be a bankruptcy case in California, which this court knows because the court had asked us to brief that issue prior to filing the appellant briefs, so that it knew whether it had the right to go forward with respect to this appeal, or there was a stay that prevented it from doing so. The court knows that there was a bankruptcy filing, and we had filed a lot of documents with respect to that filing. And mostly that is finished, except that the bankruptcy court has some litigation before it that I think it's waiting for the determination of this appeal before it can conclude. But that isn't really something, I mean, outside of certainly informing the court as to what that is. I mean, that I don't think that necessarily binds this court in any way. It can still make a decision with regard to this matter. So all of that aside, we would ask that the court would reverse the trial court matter in this issue on the sole issue of damages and send it back for further proceedings consistent with its opinion. And I thank the court for having this hearing and considering this matter.
All right, thank you. Thank you both for appearing. And I guess this video, Zoom, Facebook was beneficial, at least to some degree. I assume you're still in California, Ms. Steffen?
Yes, I am.
Yeah, so at least that made it a little bit easier for you to appear here today.
Thank you.
And so at any rate, so we thank you both for your presentations, and we will take the matter under advisement and issue a written opinion that will be sent to both sides. And you can, if you're anxious, you can watch for the opinions to be released electronically. We do release them via our website and the Supreme Court website. So I have a Supreme Court website. Thank you very much. I hope you both have a good day.
Thank you.